This is part 2 as far as our lecture series on the Indian Penal Code of 1860 is concerned. In the first part we learned that Indian Penal Code is a substantive law which defines rights, duties and liabilities of an individual. But the procedural aspect, namely mechanism to implement the provisions of the substantive law, is laid down as far as the Criminal Procedure Code of 1973 is concerned. Now, as a student learning law, you will come to know, during course of time, you should always have what is known as holistic approach from the point of view of understanding the law. So, when you want to know any case decided either by the Supreme Court or by the High Court, maybe dealing with section 300 of the Indian Penal Code, which defines the offence of murder. But to understand the decision that is given by the court of law, you must know Indian Penal Code, you must know the provisions of the Criminal Procedure Code, you must know the provisions of the Indian Evidence Act, and then only it is possible for you to understand the case, otherwise not. And why I refer to the cases that are decided either by the Supreme Court or High Court is for the simple reason. As a student of law, never forget the importance of Article 141 of the Constitution of India. And Article 141 deals with law declared by Supreme Court to be binding on all courts. And if you read the article, it says, the law declared by the Supreme Court shall be binding on all courts within the territory of India. So the law that is declared by the Supreme Court becomes law of the land. And as you must know the law of the land, it is necessary for you to know the decision that is given by the Supreme Court. Maybe we shall be dealing with some of the cases, because if the case decision given by the court, namely the High Court or the Supreme Court, if it has become law of the land or if it has become law of the state, you must know it. For example, during course of our lecture, we shall be dealing with section 309 of the Indian Penal Code, and that section deals with attempt to commit suicide, which is an offence. Now, to know the law relating to attempt to commit suicide, we shall be dealing with Gan Kaur versus State of Punjab, which was decided by the Supreme Court in the year 1996. We shall also deal with P. Ratinam's case, which was decided by the Supreme Court in the year 1994. And as a student studying in a particular state, we will have to refer to the decisions that were given by the High Court at that particular point of time. As a student learning law, should always remember, if a decision is given on a point by the Supreme Court, that becomes law of the land. If a decision is given by the High Court, that becomes law of the state. A decision that is given by the High Court can be overruled by the Supreme Court. A decision that is given by the Supreme Court can be overruled by the Supreme Court. But then, a decision that is given by the Supreme Court cannot be overruled by the High Court. And then, what becomes a law? The law that is laid down by the Supreme Court becomes law of the land, of which you should take note. Whether it is necessary for you to refer to the case law every now and then? Yes. If it is because of the case law that the law has been laid down, with which we shall be dealing during course of our lectures, no doubt about it. But then, if by reading the bare section, by going through the illustrations, if you are in a position to tell as to what are the ingredients to constitute liability, from my point of view, that serves the purpose from the point of view of understanding the concept with which we are dealing, with which we will continue our discussion during course of our time. Now, for the purpose of understanding legal language, at times, when you start reading the same, you will find out that sometimes it becomes difficult. Why it is difficult? Because it is different. And hence, by reading it, as you are used to it, it is only because of the practice. And what do you mean by practice? You read a lot, you listen a lot, and when there is repetition, then naturally it will be very easy for you to understand the provisions with which we shall be dealing. For example, as I told you, during course of time, when we shall be dealing with section 378 of the Indian Penal Code, now if you read section without, though we have not dealt with section 378 of the Indian Penal Code in detail, if you carry out analysis of the section yourself, you will come to know that there are 5 ingredients to constitute liability for the offence of theft as it is defined by section 378 of the Indian Penal Code. 1. As you go on reading, you will come to know theft can be committed with respect to movable property only. So there can be theft only with respect to movable property. When there can be a theft provided the property was in possession of some person. What is required to be done? One who wants to commit the offence of theft must to move the property out of the possession. Fourthly, he must to move the property out of the possession without the consent of the person. And then, as we had started with one state of mind of an individual to constitute liability for the offence of theft, intention must be dishonest at the time of moving the property. So this is analysis of the section. This practice you should follow, I shall follow, no doubt about it. But you should also, try yourself that I have read the section and from my point of view, these are the ingredients to constitute liability as far as this section is concerned, and then you try to find out the meaning. What do you mean by movable property? In order to know what do you mean by movable property, when it becomes movable property, can you convert the nature of the property? Can immovable property become movable property and movable property becomes immovable property? All these aspects you will learn by reading the illustrations which are given. But then, along with the illustration, if you read section 22 of the Indian Penal Code, that will tell you what do you mean by movable property with which we shall be dealing. Dishonesty is defined by section 24 of the Indian Penal Code. But then when you read section 24, it says, whoever does anything with the intention of causing either wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. In other words, in order to understand what do you mean by dishonesty, you must know what do you mean by wrongful gain and wrongful loss. And for the purpose of knowing what do you mean by wrongful gain and wrongful loss, if you refer to section 23 of the Indian Penal Code, it says, a wrongful gain is a gain by unlawful means of the property to which person gaining is not legally entitled. And then if you read what do you mean by wrongful loss, it says wrongful loss is a loss by unlawful means of the property to which person losing is legally entitled. So now, as you try to understand, that is what is wrongful gain and what is wrongful loss accordingly by reading the sections, now this is the time for you to understand the importance of it. And then as you go on, as I told you, that you go on reading the same, this will help you from the, this is I am telling you at the time of introduction. Start learning. Though you, if you know Criminal Procedure Code, so far so good. If you know Indian Evidence Act, so far so good. But try to find out whenever you are reading a particular case law, try to find out and start learning yourself, so that becomes very easy for you to have mastery over the subject. Now here we are dealing with criminal law. What is theft? Theft is a criminal wrong. Why we say it is a criminal wrong? Because that affects the society at large. If you enter into contract with somebody, as per the provisions of the Indian Contract Act, right from section 1 up to section 75 of the Indian Contract Act, that these deals with general principles of the contract. And this is the time for me to tell you that, well, when you talk about Indian Penal Code is not only the substantive law. Along with Indian Penal Code, if you refer to the provisions of the Motor Vehicle Act, if you refer to the provisions of the Prevention of Corruption Act, if you refer to the provisions of the Prevention of Food Adulteration Act, there are many enactments where the refer to the provisions of the Dowry Prohibition Act. So these are the enactments where the offences are defined. So these are substantive laws. Similarly, but then the nature is the offence is defined, and then what is an offence? This is a criminal wrong which affects the society at large. As in case of Indian Contract Tax that I told you, we are concerned with only two persons. It doesn't affect the society at large. And hence, relationship is between only two persons, and hence we say that the nature of the wrong is what is known as a civil wrong. Now, why I say that simultaneously, if you adopt this approach of trying to find out the meaning, or try to find out that is it possible for me to know the same? You go on asking one question, why, and it is possible. Imagine a situation where there is a simple case of breach of contract, and then is it only the Contract Act that you are going to read from the point of view of knowing everything? No. For the purpose of remedy, what is contract? Yes, you will understand. What do you mean by breach of contract? You will understand by reading the provisions of the Indian Contract Act, no doubt about it, right from section 1 up to section 75 of the General Principles of Contract. But then, to know what if there is a breach of contract on the part of one person, what can be done on the person who is an aggrieved person, and for that you refer to what? Contract Act is a substantive law. Indian Partnership Act is a substantive law. Sale of Goods Act is a substantive law. Transfer of Property Act is a substantive law. No doubt these are all, civil laws, no doubt about it. But then, which is the law that implements the provisions of the substantive law? You refer to the provisions of the Civil Procedure Code. And when the matter is taken before the court of law, court is always guided by what? It's not, court will not rely on what you say, but the court will always ask you question. How it is possible for you to prove your point in a court of law, and then court will always go by the provisions of the Indian Evidence Act of 1872, right from section 1 up to 167 of the Indian Evidence Act. And then the other law, as far as this case of breach of contract is concerned, which will come into operation, is you go to the court of law, and you must go to the court of law within stipulated period of time. If you go to the court of law after expiry of the period of limitation, your claim is barred by the provisions of the Indian Limitation Act, because you must know law helps diligent and not indolence. So you must know Limitation Act also. When you want to go to the court, you have to pay court fees, and hence you must know that law. When you want to apply for specific performance, you must know the provisions of the Specific Relief Act. So try to have this approach. You simultaneously try to ask yourself many questions, and then once you try to get answers to the question, you will have absolute clarity regarding the subject with which you are dealing. It is irrespective of the nature of the law, whether it is Indian Penal Code, whether it is any other law, but this should be your approach. And hence, mind well now that you must be in a position to read the law, you must be in a position to understand the thing, and for that sincere efforts, or there must be practice on your part which is required to be done by you. With this now, when we shall be, as I told you, we shall be dealing with the provisions of the Indian Penal Code during course of our lecture. We shall be dealing with various chapters as far as Indian Penal Code is concerned. For example, when we will deal with offences with respect to the property, against the property, we shall be dealing right from section 378 up to section 462 of the Indian Penal Code. And then when we start, as I told you, right in the beginning, you must know the offenses with which we shall be dealing. Section 378, theft. Section 383, extortion. Section 390, robbery. Section 391, dacoity. Section 403, dishonest misappropriation or criminal misappropriation. Section 405, criminal breach of trust. Section 410 defines what do you mean by stolen property with which we shall be dealing. Section 415 defines what do you mean by cheating. Section 416 defines what do you mean by cheating by personation. Section 425 defines what do you mean by mischief. And then this chapter deals with movable as well as immovable property. Section 441 defines what do you mean by criminal trespass. Section 442 defines what do you mean by house trespass. Section 443 defines lurking house trespass. Section 444 defines lurking house trespass by night. Section 445 defines housebreaking. And Section 446 defines what do you mean by housebreaking by night. And this is exactly the time for me to tell you that this is necessary. One thing is very important. You must be in a position to correlate. In the sense, when you want to know what do you mean by dacoity, and if you merely concentrate on section 391 of the Indian Penal Code, it may not be possible. Because what is dacoity? As we will learn in detail, dacoity is an aggravated form of robbery. In other words, in order to know the offense of dacoity, which is defined by section 391 of the Indian Penal Code, you must know the offense of robbery, which is defined by section 390 of the Indian Penal Code. And if you start reading wording of section 390 of the Indian Penal Code, which says, in all robbery there is either theft or extortion. In other words, what is robbery? Robbery is an aggravated form of either theft or extortion. So first of all, you must know what do you mean by theft. Then you will try to understand when theft is robbery. You must know what do you mean by extortion, and then you will come to know when extortion is robbery. And when you come to know robbery, you will come to know when robbery is committed by 5 or more persons, or when there is attempt on the part of 5 or more persons to commit the offense of robbery, that amounts to the offense of dacoity. Similarly, when you are dealing with the offense of housebreaking, which is defined, housebreaking by night, which is defined by section 446 of the Indian Penal Code, you must know housebreaking by night is an aggravated form of housebreaking. So to know the offense of housebreaking by night, which is defined by section 446 of the Indian Penal Code, you must know the offense of housebreaking, which is defined by section 445. And in order to know what do you mean by housebreaking, which is defined by section 445, it is an aggravated form of house trespass, which is defined by section 442. And what is house trespass? House trespass is an aggravated form of criminal trespass, which is defined by section 441 of the Indian Penal Code. This should be the approach. The other illustration which I had given you regarding voluntarily causing grievous hurt, then during course of time you will come to know what do you mean by hurt. Section 319 says, whoever causes bodily pain, disease or infirmity to any person is said to cause hurt. And then section 320 says, the following kinds of hurt only are designated as grievous, and 8 categories are enumerated. So in order to know grievous hurt, first of all you must know hurt. And this is the approach which we will have to follow for the purpose of dealing with the chapters as far as various sections as far as the Indian Penal Code is concerned. Now, we will try to understand importance of various chapters during course of time. And then as we go on starting with each chapter, we shall be dealing with various sections, because of which the act which amounts to an offense is defined accordingly. And then the usual method that we shall be following is that we shall refer to the illustrations. I mean, you have to read the illustrations which are given in the Bare Act, no doubt about it. Simultaneously, we shall be taking into consideration many more illustrations, and it is only with the help of the illustration that it will be possible for us to know the ingredients of the sections very clearly, with which we will continue our discussion as far as our next part of series of lecture is concerned.